This is immigration attorney Parviz Malakouti, and one question that I see all the time from dreamers that I'm in touch with, either in my practice or my Facebook group or YouTube channel, is can I have a child of mine that's a US citizen petition for me? Okay, a lot of dreamers have children, okay, and they want to know if their children was born in the United States, if the child is a US citizen, can that child send a petition, I-130 petition for alien relative, to petition for the parent? The answer is yes, they can petition once the child reaches the age of 21 years of age, okay? So most dreamers that have children don't have a child that's 21 because dreamers, at least if you define it by qualification for DACA, the oldest that DACA recipients that there are right now are, I think, is 39 years old, something like that, because you have to be 31 maximum by June 15, 2012. So most dreamers, or at least DACA recipients, don't have a child yet that is 21. But when that child does turn 21, if they're a US citizen, they can petition for you. But that's just the first potential issue, okay? This is the part where I see a lot of confusion, okay? A lot of dreamers think, okay, oh great, well if my child can petition for me when they turn 21, they're gonna send the petition, I'm gonna get the green card, it's gonna be the end of the story. And unfortunately for a lot of dreamers, that is not the end of the story. And that's because in addition to having the green card, the visa available from a family member petitioning for you, if you are in a situation where you're undocumented and you have a previous immigration violation, which by the way, vast majority of DACA recipients and dreamers do have a previous immigration violation, either an entry without inspection or unlawful presence or both. But if you have any other previous immigration violation, then you need to make sure that you're screened for issues, okay, that would prevent you from being able to take advantage of that green card. In immigration parlance, those issues would be called inadmissible, okay, inadmissibility, being inadmissible, or for example, having what's called a bar to adjustment. A bar to adjustment means a bar to adjustment of status, and adjustment of status, of course, is the green card process for somebody who starts in the United States and stays in the United States applying for a green card, okay? So for those individuals that are dreamers, they have children that are approaching 21 or already 21, they can send the petition, okay? Whether the dreamer is going to have an immigration issue, okay, that needs to be addressed, okay, is going to depend on the individual facts of the dreamer situation, okay. The relevant factors are going to be, first of all, how did that dreamer come to this country? Did they enter without inspection, aka illegally, or did the dreamer enter on a visa and then overstay, okay? That's going to be one factor. The second factor is going to be how much unlawful presence does that dreamer have, if any, okay? Unlawful presence, very complicated subject, but in a nutshell, unlawful presence means time that somebody is in the United States after the age of 18, but without having any immigration status or DACA or a application for a green card pending, okay? That's in a nutshell what unlawful presence means. So these are the types of issues that a dreamer is gonna have to be screened for, okay? Now, I'll just give an example of a situation in which a dreamer, it might be as simple as the dreamer's child, US citizen child, turning 21 and then petitioning for them. If you have a dreamer, okay, that entered with inspection, so they entered with a visa, okay, they overstayed the visa, and then they got DACA before the age of 18, and they kept DACA all the way up until present day, okay, all the way up until present day, okay. That dreamer had an entry with inspection and may not have any unlawful presence, okay. In that case, it may be possible, okay, that the child petitioning for that dreamer, okay, is going to make a green card available that the dreamer can take advantage of by filing an application for adjustment of status and not have to deal with any waivers of inadmissibility or have to go abroad for consular processing or deal with really any of those more complicated aspects of immigration law that a lot of dreamers have to deal with. That's kind of an ideal situation, okay? Not all dreamers are in that situation, okay? So really, in order for a dreamer to know, okay, what are the issues that are gonna come up if a child petitions for them, they really need to have a consultation, they need to have an intake and basically be screened for those type of issues. Again, starting with really the two most important, which is how did the person come here and how much unlawful presence did they accrue, if any. There's a lot of other issues as well that are relevant, but those are really the starting points. Those are the two most important issues. Anyway, so I hope that video helps for you guys. If you're a dreamer, if you like discussing these type of issues, feel free to join our Facebook group. We have a Facebook group called DACA Dreamers Moving Forward, 1,400 members strong now. We talk about these issues. I put my videos up there. I put out my tips, my thoughts about immigration news related to dreamers. You're welcome to join. Just make sure you answer all the questions. And yeah, that's it. I hope everybody has a great day.